Hi, I'm Richard Pennington. I'm an NIGP member, now retired, formerly the General Counsel for NASPO Value Point. I practiced state procurement law in Colorado in the late 1990s, and I had some private practice after that. And I'd like to talk to you a few minutes about attorneys and their roles and their ethics and some of the professionalism issues. One of the things that really amazed me is when I came across this quote, and this was in the McEwen-Pitzer Fundamentals of Leadership and Management in Public Procurement. It's humorous. There's a little bit of truth to it, but I wanted you to focus on the part about the role of the legal officer being an advisor and counsel, not taking over procurement operations. Attorneys have ethics just like you, and they've got professionalism issues that arise. But one of the most difficult things that I think is the role. Thing I always hated when I was advising the state controller in Colorado, and they approved the state contracts. I always hated when a client came to me and said they had been to the controller's office, and they had said, when talking about an indemnification clause revision, for example, that had been proposed, they'd say, ask Pennington. If it's okay with him, it's okay with us. And I never liked that because my role was an advisor to let them know what the options were and how the different alternatives would play out. But I wasn't the person making the call. So talk to your lawyer and make sure there's a clear understanding when you send them something, what you're asking them to do. They may have authority under ordinance or statute to actually make the call on something like a limitation liability clause, but typically they're advisory. It's different in litigation. Attorneys in litigation are officers of the court. They have obligations that they owe to the judicial system. So they'll take the primary lead on those, making sure that they can, in good faith, sign pleadings and take positions in court. One of the things that may affect you is the duty to preserve evidence. In most jurisdictions today, attorneys have a duty to inform clients about the duty to preserve evidence when litigation is filed, threatened, or reasonably anticipated. You need to talk with your counsel about the timing of that and how broadly that duty of preservation goes and who's subject to it. Especially with respect to electronic records, close coordination with counsel is important. Attorneys have a well-developed ethical code. The first canons of professional ethics were adopted in 1908. And now most states, California is an exception, but most states follow the American Bar Association Model Code of Professional Conduct. One of the probably most important parts of that are the rules and conflicts of interest. Attorneys may not represent a client if the representation involves a conflict or some other adverse interest to a current or a former client. When you've got attorneys that have been in public service for lengthy periods of time, it's usually not an issue. But occasionally, especially if you're a smaller local government that has outside counsel, you may end up with a situation where they can't actually represent you in a matter because they have another client that's involved in it, or maybe a prior matter involving that company. These rules sometimes can result in delays, and sometimes you may get a question or a request to waive a conflict of interest, and so the attorneys are obligated to fully explain the issues and the options there. Attorney-client privilege is not only an ethical obligation, but a rule of evidence. Excluding privileged communications, for example, from court proceedings and even administrative proceedings. An attorney may not disclose those communications, but there's a little urban legend that if you have an attorney in the room, you're good to go, and nothing that's said in that room is disclosable or would be admissible in a court action. Well, that's not true. It's important to talk with counsel about that privilege and have a complete understanding and ask questions like, do you want everything in writing? If it is, how should it be legend or to put a legend on an attorney-client privilege? Are there some things you just need to pick up the phone and talk about? And what about multiple parties? What about when the architects are involved in some kind of a case involving a claim that specifications were defective? Can you freely talk to their attorneys? I mean, there are questions you need to talk about. Professionalism has become a critical issue now in the practice of law, especially in urban areas, because there's a great amount of incivility. Some attorneys are jerks, and we don't really have that problem as much in the public law practice, at least in my experience, but it is happening. And occasionally you will encounter issues with this. So what we're going to show you as we exit this brief introduction to attorney kind of roles and ethics and professionalism is a short vignette that's published by the Colorado Bar Association, Denver Bar Association, Professionalism Coordinating Council. And this will probably prompt from some questions, and we will talk about those briefly after you see it.
Are you ready? We close in 90 minutes.
I'm a little concerned about the liquidated damages clause.
Our client wanted it in there, so it's no concern.
My concern is we emailed the draft with the clause inserted last night at 10 p.m.
So?
So, we closed in 90 minutes, and we haven't talked to the other side about it.
And your point?
This is a $2 million deal. Don't you think we should call and talk to them about it?
We sent them notice. If they didn't notice, that's their problem. Caveat emptor. Hey, who else uses Latin every day except for us in the Catholic Church?
They don't even use it. My point is, what if they bring up the clause at closing?
Their firm is something out of an Adam Sandler movie. Even if they do catch the clause, they'll roll over on it. They always do. And when that happens, we look like geniuses to our client. Trust me.
So what did you think of that? What would you do if you were in a meeting like that among counsel? You know, counsels have an ethical obligation not to misrepresent. Does this rise to the level of a misrepresentation? The reason that's important when we show this to attorneys in Colorado is if you believe there's a breach of the ethical rules of professional conduct, there's an obligation by attorneys to report them to the Supreme Court. There's a split of opinion when I've done seminars about whether it's unethical or simply unprofessional. But the question for you is, does that matter to you? Is this the kind of conduct that you would tolerate? Do you think the deal may be at risk under perhaps a misrepresentation theory? Or if all of that really isn't going to be satisfied by the evidence, how do you feel about what you just witnessed? You know, the procurement professional is not expected to sort out all these issues. Attorneys are ethically required to clarify the nature of the representation, the attorney-client privilege, the conflicts issues. But you as practitioners should be aware that issues can arise about confidentiality and these types of important issues. Discuss them with your counsel. Sometimes attorney obligations with respect to conflicts and confidentiality and the role of the attorney can affect your operation. But be aware that attorneys have these concerns also. Hope you learned something. Thank you.